Good day, class. We are now in Article 100 to 103 of the Revised Penal Code. This is Article 100 is one of the important provisions of the Revised Penal Code. So you have to memorize this one with all your heart, with all your soul, or etc. pa. Diba? So because um, magbalik-balik na siya sa mga examinations, no? Okay, we are now in Chapter 1, the civil liability. Person civilly liable for felonies, even though we are talking about criminal liabilities, but apart from that, there is also a civil liabilities of a person committing the felony. Article 100 provides civil liability of a person guilty of felony. Every person criminally liable for a felony is also civilly liable. So if you have committed a crime and there is a corresponding penalty on a certain crime you could have committed, there is also a corresponding civil liability of a person committing the felony. And what is this civil liability? This entails payment of the moral damages or payment for the injuries caused by a certain person who committed a felony, or a payment for the damage of the property committed by a certain person who commit the crime. Now we have here civil liability of a person guilty of a felony. In crimes against persons, like the crime of physical injuries, the injured party is entitled to be paid for whatever he spent for the treatment of his wounds. So technically, the civil liability of a person na nakakommit of physical injuries, ang iyang civil liability is the money spent by the victim of the treatment of his wounds, the doctor's fees, and for medicine, as well as the salary or wages unearned by him because of his inability to work due to his injuries. For example, imo siyang gidunggab, no? And that is physical injuries. Naigo lang ka or something, you stab him or you punch him. No, you have a fist fight, and then technically na-injured siya, and then because of the injury na imong i-commit towards him, wala na siya ka-work. For instance, na-work siya sa warehouse, and then ang iyang salary dito is 300 pesos per month. I mean 300 pesos per day. So you have to compensate him for that unearned na mga days, no, like for instance 10 days. So that is 350 times 10, that is 3,500. Apart from the reimbursement na iyang gastos sa iyang medicine and doctor's fees. So you have to pay. And that payment is what we call civil liability. No, sa imuhang gi-commit na physical injuries towards him, which is the criminal liability. Now, we have here moral damages may be recovered in a criminal offense resulting in physical injuries and the crimes of seduction, abduction, rape, or other lascivious acts, adultery or concubinage, illegal or arbitrary detention or arrests, illegal search, libel, slander, or any other form of defamation, and in malicious prosecution. For instance, the case of libel, no, that is a criminal act, and there is a corresponding criminal liability. Now, apart from the criminal liability, there is also corresponding civil liability of the crime of libel, like the moral damages. For instance, na pakaulawan siya, no, because he is or she is a public official, no, holding with a lot of subordinates. Napakaulawan siya sa iyang mga subordinates. So technically, he or she can claim moral damages, no, kay nababaihang moral as a public official. We have also exemplary damages as part of the civil liability may be imposed when the crime was committed with one or more aggravating circumstances. So to further explain that one, we have 2230 of the new Civil Code, mga exemplary damages. Now, what is the basic principle in civil liability ex-delicto? Every person criminally liable is also civilly liable. Now, what is this civil liability ex-delicto? So when we talk about ex-delicto, it is from a wrong or mga civil liability arising from the crime, no, kaning ex-delicto. So para di kayo mo malibog, ang ex-delicto is kanang wrongful act, no, and actions arising from a wrong other than a breach of contract, no, mga civil liability arising from the wrong act or wrongful act. Okay, however, if a person is acquitted from a criminal charge, you have here criminal charge, it does not mean, no, that he is civilly free. Also, because the quantum of proof required in criminal prosecution is beyond reasonable doubt. So, kailangan beyond reasonable doubt in civil liability. So, if the crime, for example, is na tagaan-og ka ng judgment, no, and then because lack of kanang evidences, no, presented in court, so technically ma-dismiss ang case because of the lack of evidence, and there is a doubt when presenting the evidence, and there is a doubt when if the crime is committed by a certain person, so technically ma-dismiss siya. But because of that, since that is the promulgation of judgment kay lack siya of evidence, it doesn't mean he is civilly free. Magpadayon gyapon ang civil liability because na acquit lang man siya kay walay mga concrete nga evidence, no, but there is a crime na iyang nakamit. It is merely preponderance of evidence kung sa civil liability, and sa criminal liability is the beyond reasonable doubt, the judgment beyond reasonable doubt. Now, to be free from civil liability on account of acquittal, therefore, this must be based on the fact that he did not commit the offense, no? For if his acquittal is based merely on reasonable doubt, he may still be liable. But since ang iyahang acquittal is wala gid siya nakakommit, no, sa offense, as if na-prove sa court, na-prove sa defense na wala gid siya nakasala. So technically, mawala ma-exonerate ang iyahang civil liability, no? In such case, it may only be that the facts proved did not constitute the offense charge, or the prosecution failed to prove an element of the crime. Even if, halimbawa, na siya criminal liability or na-convict na siya sa crime committed, and then hangyo siya nga, pwede wala na civil liability. So, pwede, provided nga it is expressly waived by the offended party. So, dapat na ikasulatan. No, nga, okay, sige, waive na lang ng civil liability. Di man gyapon kakabayad kay naka sa presohan. Okay? So, pwede, basta na it is expressly waived. When we talk about expressly waived, kung expressly, dapat na siya sa in writing. So, kung expressly in writing ang tawag ana, no, Mungutana mo, nganong di na lang in writing, sir? Maugid na siya ang term. In writing. Okay? Now, what are the two kinds of acquittal and their effects on the civil liability of the accused? The first acquittal is an acquittal on the ground that the accused is not the author of the act or omission complained of. Dili siya ang author. No? This instance closes the door to civil liability. So, wala siya civil liability kay di man siya naghimo sa act or omission. The second instance is an acquittal based on reasonable doubt on the guilt of the accused. Katong, as I was saying, no, that based sa mga evidence nga gi-present and then kulang ang mga ebidensya. And there is doubt on the guilt of the accused. But however, the judgment in the criminal proceeding cannot be read in evidence in the civil action to establish any fact there determined, even though both actions involve the same act or omission. For instance, but this is not kanang absolute. Only for instance sa mga cases like kanang nakabangga. And then, of course, nanay damage to property. Kinahanglan gyapon nimo siyang bayaran. Even though you are acquitted with the criminal offense because kulang og ebidensya, still, na may nadaot na mga butang. So you have to pay for that. And there is civil liability in the case committed. As a general rule, kung halimbawa na yung mga doubt, you have to go back from the provisions of the law that any person who are criminally liable shall also be civilly liable. The acquittal of accused extinguished both criminal and civil liability, as it is clear from the order acquitting them that the issuance of the checks did not constitute a violation of Batas Pambansa bilang 22. Consequently, no civil liability arising from the alleged delict may be awarded. Technically, there is no civil liability because wala na proof, or he was acquitted on the bouncing checks law, kanang magpa-exchange ka og cheque tapos walay sulod ang imong kwarta, nagpa-exchange ka dito, walay sulod. So pwede kang makasuhan ana under BP 22 under the bouncing checks law. And then in this case, wala man siya naka-violate sa BP 22, so technically wala siya civil liability arising from the alleged delict. Now we have here exceptions. Na mga exceptions to the general rule. And one of the exceptions, as I have said, there is Article 100. It was not stipulated in Article 100, but nonetheless it is stipulated in the jurisprudence, some jurisprudence. There are a lot of thousands of jurisprudence. In the case of Oxena versus Ikamina, this was promulgated last January 22, 1990. The crime of treason, kanang talk about treason kanang you are betraying our country, betrayal of one's country. Rebellion, kabalo naman siguro mo silang rebellion. Espionage, like kanang you are spying, nag-spy ka. Like, gisugo ka sa US to obtain na mga military communication or informations sa Philippines. So, pwede kang kasuhan ng espionage, but again, there is no civil liability. Pero dili na siya basta-basta ang kaso. Contempt. You are cited into contempt because wala ka nituman sa order sa balaod. Like, special civil actions, na for injunction, na papahawaon ka or eviction sa imuhang house, and then again, wala ka nituman sa order sa court. So you'll be cited into contempt. And others wherein no civil liability arises on the part of the offender. Katong mga cases like one of your classmate raised, no, katong gisagpa ang mayor, there is no exact na mga measurements whether wala siya civil liability. No na, I've read that one in Reyes na annotation, but again, there is no legal basis dito sa yung annotations. But nonetheless, it could be, but it is debatable. So to be safe, we are going to have these exceptions ng mga jurisprudence na supported by legal na mga legal matters. I mean, mga legal basis like jurisprudence and legal provisions of the law. And the ultimate analysis, what gives rise to the civil liability is really the obligation of everyone to repair or to make whole the damage caused to another by reason of his act or omission, whether done intentionally or negligently, and whether or not punishable by law. Another exceptions, the civil case for damages is not barred since the cause of action of the heirs is based on the quasi-delict. Again, kaning quasi-delict, katong mga unintentional na mga wrongful act, though it's wrongful act but dili siya intentional. For anang nagdula mo og baseball and then technically ang ball is napadulong sa sakyanan, no? Tapos nabuwak ang sakyanan. So technically there is a damage to property. Even if damages are sought on the basis of crime and not quasi-delict, the acquittal of the bus driver will not bar recovery of damages because the acquittal was based not on the finding that he was not guilty, but only on the reasonable doubt, since there is, in the case of Guaring Jr. versus CA, ang driver diri is na-acquit because wala na proof sa prosecution nga naa siya negligence sa ihang part, no? Kaya ang kaso ani is whether liable siya na there is negligence sa ihang part, and since na desisyonan nga wala siya negligence sa ihang part. But again, there is nagyapon siya civil liability because na may mga na-injured, and in fact na ay mga namatay, no, sa kaning kaso. So technically, makabayad yapon siya mga damages or ang company, no, even though he was exonerated from the criminal offense. We have here Article 101, Rules regarding civil liability in certain cases. Rules, the exception from criminal liability established in subdivisions 1, 2, 3, and 5. So nadiri ang 1, 2, 3, and then 5 later on. And 6 of Article 12. No, you have to read that one again. In subdivisions 4 of Article 11. So in Articles 12, that is the circumstances which exempt from criminal liability. And Article 11 is the justifying circumstances. Now we have here, according to the law, that these enumerations does not include exceptions from civil liability, which shall be enforced subject to the following rules. Natin mga rules, no, governing regarding the civil liability in certain cases. So we have here, okay, mo ni siya ang katong justifying circumstances na i-enumerate sa Article 101. You have to read that one. We have rules regarding civil liability in certain cases. Now, as mentioned in Article 101, those in the circumstances or exempting circumstances and justifying circumstances. For instance, in Article 12, in cases of subdivisions 1, 2, and 3 of Article 12, the civil liability for acts committed by an imbecile or insane person or katong buang, and by a person under 9 years of age, or by 1/9 but under 15 years of age. Now, in this case, we have new law. It is not 9 years of age no para ma-exonerate siya sa criminal liability, but 15 years of age under the RA 9344. Now we have here, if they acted without discernment, no, katong mga nakakommit o criminal liability, itong 15 years under, shall devolve, no? Talk about shall devolve upon those having such person under their legal authority or control, matransfer ang ilahang criminal liability to those person na over control with them, like their legal guardian or their parents, because again, they should be acted with diligence of a good father of a family, or a diligence or ordinary diligence na bantayan ng mga bata or kaning mga insane person. So kung naa sila yung mga guardians or legal authority, we talk about legal authority, those mga guardians, mga parents, control over them. So ang kanang ilang mga civil, though they don't have any criminal liability, no, as well as with those parents, but ang ilang civil liability ma-devolve or ma-transfer sa nagbantay or mga guardians or parents sa kaning mga insane person or imbecile o kaning mga children under 15 years of age, no? So there be no person having such insane, imbecile, or minor under his authority, legal guardianship, or control. But again, matransfer lang siya kung there is negligence on their part. Pero kung walay fault or walay negligence sa part sa guardian, because kanang murag nidagan or fugitive to them, no? Kung wala sila'y fault, then dili ma-devolve o dili ma-transfer sa ilaha ang civil liability. But if the legal guardian or the legal guardianship or control, atong control sa mga imbecile or insane persons or children under 15 years of age, ang katong and these persons, no, acting, so if they're acting with due diligence of their part as a legal guardian, so such insane, imbecile, or minor shall respond with their own property, katong property nila, atong pangbayad, but exempt for those property nga from execution na sa korte. So dili to pwede nga katong murag ng mortgage na in accordance with the civil law. Okay, again, you have to memorize this one, to familiarize 1, 2, and 3 in Article 12, the exempting circumstances, and of course Article 4, and we have also paragraph 4. Now we have here another rules. Tingnan natin kung anong rules. Okay, second rule regarding civil liability in certain cases. Now, in cases falling within subdivisions 4, here, subdivisions 4 of Article 11, the justifying circumstances, which provides that any person who, in order to avoid an evil or injury, does not act which causes damage to another, or this is what we call the self-defense. The persons for whose benefit the harm has been prevented shall be civilly liable in proportion to the benefit which they may have received. So if uh, for example, there is some certain crime na commit, no, of a certain person under justifying circumstances, and then ang nakabenefit kay ikaw because di tungod sa imuha di siya makakommit og crime, and then because of that crime he has committed, naka-incur siya og mga damages. Of course, you have to pay. Kung ikaw naka-benefit, no, sa crime or proportion nga um, in which the harm was prevented because of the justifying circumstances committed by a certain person as a protection sa imuha, then you will be held civilly liable of the damage done. And the court shall determine in sound discretion the proportionate amount of which each one shall be liable. When the respective shares cannot be equitably determined, even approximately, or when the liability also attaches to the government or to the majority of the inhabitants of the town and all events, whenever the damages have been caused with the consent of the authorities or their agents, indemnification shall be made in a manner prescribed by special laws or regulations. Because, for example, kanang mga ng mga intruders sa inyong subdivisions, no? And then, technically, because sa inyong pagpugong o mga police officer, i-prevent nila ang mga intruders, and then nangaguba ang mga gates, nangaguba ang mga roof sa houses. So technically, those who benefited from the prevention which causes harm to the residents of a certain subdivisions or a certain subdivision will pay the indemnifications. No, it will be divided. But if dili or there is no approximately or even approximately dili gyapon siya ma-determine kung pila ang inyong bayron, no? So there is a special laws or regulations regarding with that one. So dili na ang mag-prevail ang Article 101. So naa siya mga rules governing that indemnification. And the third, in cases falling within subdivisions 5 and 6 in Article 12, which provides any person who acts under compulsion of irresistible force, and those any person who acts under the impulse of an uncontrollable fear of an equal or greater injury. So that persons using violence or causing the fear shall be primarily liable and secondarily. Or if there be no such persons, those doing the act shall be liable civilly, saving always to the latter that part of their property exempt from execution. Okay, we have to familiarize this one. In accordance with Article 101, the rules regarding civil liability in certain cases. Now we have here Article 102, subsidiary liability of innkeepers, tavern keepers, and proprietors of establishments. So we have here Article 101. The innkeepers, tavern keepers, and proprietors of establishment are also liable for the crime committed in their establishments. And in all cases where a violation of municipal ordinances or some general or special police regulation shall have been committed by them or their employees, so they are subsidiary civil liable. There is a subsidiary civil liability of this mention. Innkeepers are also subsidiary liable for the restitution of goods taken by robbery or theft within their houses from guests lodging therein. So they are subsidiary liable, and they have to indemnify the guests na nakalodged sa ilaha, or for the payment of the value thereof, provided that such guest shall have notified in advance the innkeeper himself, or the person representing him, of the deposit of such goods within the inn. But if there is no notification coming from the guests na nada sila nga nakabutang, then the innkeepers are not liable. They have to inform first na naaday ko'y camera din ha, sir, ma'am, o ka ng refrigerator na akong dala, and then here comes nawala, pero wala ka balo ang innkeeper, so the innkeepers will not be subsidiarily liable civilly, and shall furtherance have followed the directions which such innkeeper or his representative may have given them with respect to the care and vigilance over such goods. So kung i-inform pa, if they are informing the innkeepers in advance that there is a certain things, so they have to ilang tatong for safekeeping, ilang hindi pa deposit for safekeeping. But since wala information prior to that, they will not be held liable. No liability shall attach in case of robbery with violence against or intimidation of persons, unless committed by the innkeeper's employees. If there is violence against or intimidation of persons, no, sa mga guests, because dili man dyan na nato maiwasan if there's violation, walay liability ang innkeepers or mga inns. Gawas lang kung ang kaning violence against or intimidation against person i-commit sa employees, sa innkeepers, so naay liability ang innkeepers. But if it is committed by a third person, wala sila liability. Kailangan magmuharang ka anong mga nag-rob ng mga tao, no, with violence and with intimidation of persons, maapil pa ka din ha. Now we have here Article 103, subsidiary civil liability of other persons. The subsidiary liability established in the next preceding article shall also apply to employers, teachers, persons, and corporations engaged in any kind of industry for felonies committed by their servants, pupils, workmen, apprentices, or employees in the discharge of their duties. For example, si teacher nagkaroon ng field trips, no, si teacher sa mga pupils niya, sa iyang grade 1 pupils. And then, gipasuroy niya ang mga pupils sa SM Mega Mall. And then, ang pupils na kabuak o kanang mga butang dito nga mahalon. So, technically, si teacher ang makabayad. No, subsidiary liable siya sa katong mga nabuak ng mga butang. You have to take good care of these children. Hindi mo patuatuan dito. Malay natin basig mga makabuak do, okay lang makabuak pero mga sama, di ba? And then kaning mga workmen, no, in the discharge of their duties during their function, nagdinunggabay dito or nanunggab o kaning mga investors. So technically, because that is your workman, so maapil ka sa civil indemnification, makabayad kag appeal mo man ang mga workmen, or even if that is your employees. Now, the question is, should a hearing for employers' subsidiary civil liability be conducted? Inabay hearing kung halimbawa, o employers na day kay subsidiary liable day ka, na kay bayro nun because of your employees, no, nga na-commit nimo. Of course, yes, no, there should be a hearing. Kay basig wala sila liability, basig dinagko ang mga liability like 1 million and up, no. The court must convince itself that the convicted employee is in truth in the employ of the employer. But if there is no employer relationship, then the employer will be exonerated from civil liability. That the latter is engaged in an industry of some kind, that the employee has committed a crime to which civil liability attaches, while in the performance of his duty, basig nigobiyan siya sa iyang performance sa iyang duty, katong gipapala lang siya niya pagkahuman, abot na siya dito pangguna, no, beyond the duty, dili pwede nga malayable yapon ang employee. Dili yapon siya dili ang employer. Kay because ang iyang trabaho is pagpala lang man yan, abot naman siya pangguna. So the employer will be informed, oh, and by the hearing, they will be informed nga ni ang hitabo. Okay, that is the case of Hinaha versus CA. Okay, that would be all for Articles 100 to Article 103. I hope that you read that one, no, and provide other material for your in-depth understanding. You have to read those materials given to you